Good evening, everybody. This is Jonathan Ginsberg. I hope you are all doing very, very well in this middle of summer now. We are definitely in the heat here in Atlanta. It was about 90 degrees. I was outside playing tennis and it was pretty hot. But that's what summer is supposed to be. So I hope you all are enjoying your summer, had a nice 4th, and have some great plans for the rest of the summer. So again, I just a couple of administrative notes. There will not be a live stream next week on the 16th. I think it's the 16th. My numbers right? It is the 16th because I will be out of town. I'm going to be in Michigan, Traverse City, Michigan, for a wedding. Family friend is getting married, and I don't know what my internet situation is going to be, and probably there's going to be some sort of function. So I will not be here next week. We will resume the following week. I'll make this announcement a couple of times, but we'll be back on the 23rd, but nothing next week on the 16th. So that'll be, again, we'll deal with that later on, but just want to let you know. A couple of things just what's going on with me. I've had a bunch of hearings the last few weeks. We've had good results using the grid rules a lot. And the grid rules, if you don't know, basically it recognizes that people over 50, and especially those over 55, are going to have a really, really hard time getting back into the workforce. Social Security realizes that. So even if you have functional capacity, even if you have the capacity for sit-down work or even light work, you are still disabled for Social Security rules. So it's really, really powerful. It changes the definition of disability. Person is 35 or 45, we have to prove there's nothing they can do, even a simple, let's call it a warm body kind of job. But a person who is 50, even if they could do sit-down work, they are going to be found disabled, assuming no transferable skills. At 55, even if they could do light work, and light work is standing and walking 6 hours a day, lifting 20 pounds, even if they can do that, which is a fairly robust capacity, they are disabled for Social Security purposes. So if you're over 55 and you have a diagnosed medical problem, herniated discs, cardiac issues, breathing problems, DVTs, anything that can be objectively determinable, because the grids only apply to physical limitations, what they call exertional limitations, you have a really, really strong shot at winning. In addition to that, in addition to the powerful elements of the grid, which really makes things a lot easier for me as the attorney, there's also a regulation called the POMS regulation, POMS, which stands for Program Operations Service Manual, that says that if you're 55 or older and limited to sedentary work, again, standing and walking 2 hours a day, lifting 5 pounds frequently, 10 pounds on occasion, Social Security would have to prove that you would have to make what is called a minimum vocational adjustment, and for them to find another job for you, or that you could do another job. And if you're limited to light work, then at age 60, same sort of thing applies. They have to prove that there will be minimal vocational adjustment. Essentially, that means they would have to show you could do your past work. Well, obviously, if you stopped working because you couldn't physically do it anymore, then it stands to reason you wouldn't be able to go back to that job. So my point is that if you're over 55, you have a huge advantage. If you're over 60, say between 60 and 63, 64, you have a huge advantage. So anybody who's in their 50s, it's definitely worth looking at if you're thinking about going this route. And I realize, in fact, I had this conversation with a couple of clients this week. It's a big step to decide that you are disabled, to use that label on yourself. But if you can't work and you can't make money and it's too uncomfortable and you're hurting yourself, then this is definitely something that you can look at doing, and it can be a very, very useful thing to put some money in your pocket, get you eligible for Medicare and so forth. So again, over 50 and even more so over 55, and I had several approvals for both. All my cases for people over 50 this week. A couple of one guy was over 60, and again, I had 2 hearings today. Literally, one of them, the hearing lasted about 15 minutes, and the judge says, "I've heard enough. I'm going to approve it." The second one lasted about 10 minutes. I didn't say a word, and the judge approved it. because again, the case, we had briefs, it was all briefed. I had my argument set out. The judge was like, the person's credible. I believe him. Boom, we won. So just be aware that the grids are a really, really powerful tool. And if you're going to do this on your own, and you're trying to, to win this, at the initial level, and you're over 50 or over 55, take a look at the grid rules. Gridrules.net is the website, and mention in your application, please analyze my claim under the grid rules. And if they do that, there's a possibility they could approve you early. So just a couple of thoughts, but that was my experience for the last couple of weeks. Bunch of cases approved. I think I had 3 this week and 5 last week, and I think one may not get approved, but the rest of them I think will be, because again, they were properly briefed. I had my argument set out, but it really makes it easier, much easier, when the person's over 50. So it doesn't guarantee anything, but it certainly makes it easier. Okay, let's go into the questions. Susan Schmidt, I made a congressional inquiry, as I suggested, which is always a good thing to do. And if you don't know what Susan's talking about, is once your case has been sitting at the administrative level, and I mean that's the initial or reconsideration, that's at the state agency level, not when you go to a judge, but before then, if it's been sitting there for 5 months, 6 months, that is a point where it's getting old. And of course, you're not having no money coming in. It's a real struggle. At that point, I think it's wise to reach out to your U.S. senator. You could reach out to a representative. I find that senators' offices carry a little more clout, and ask them to do what is called a congressional inquiry. And if you look at your U.S. senator's website, they all have a space or a page that says need help with a federal agency or need help with Social Security. Fill out the form. They may send you a release and basically just say, look, I've been waiting for 6 months, for 7 months. This is a real hardship on me. Please find out what the status of my case is. They're not going to put their finger on the scale. They're not going to get you approved, because you reach out to your representative, but they will move it to the front of the line. And I've got it on very good authority from talking to people that work in the hearing, in the offices, the adjudication offices, that when they get a letter or an email or a call from a U.S. senator's office, that gets their attention, because the senators obviously have control over the funding. And so Social Security administrators have told the people at the field offices and the state agencies, if you get a call or a contact from a U.S. senator, respond to it. Those cases get bumped to the front of the line, just like they do if you're 100% VA disabled. So definitely do that. Now, I wouldn't do that if it's 1 month or 2 months, because that's really not enough time. Again, just to give you perspective, back in the day, 15, 20 years ago, reconsideration initial applications were taking 4, 5, 6 months, and you get a decision. Now it's taking a year, sometimes longer. So my feeling is once you get 5 months, that is at the point where it starts to go from reasonable to unreasonable, and reach out to your congressperson. So Susan did that. They made an inquiry when informed the case was sent to medical review. I found out yesterday that a decision has been made. My case was sent for final review. I found out online my case has been approved. Thanks for everything you do for giving great advice. Okay, so and then she says, actually, they didn't receive an inquiry until 6/23. 16 days later, you were approved. So again, you see from Susan's experience, it wasn't that the congressperson got her approved, but it just got things moving. And, is it possible that when they get a congressional inquiry and they move it through and it's marked that way, and it will be marked that way, because I look at the files and it says congressional inquiry, you see it, are they going to be more inclined to say, let's just make this case go away if it's a good case, as opposed to, jerking you around and making you wait. So again, Susan's experience is very, very typical of the ones I get. And I will tell you, I mean, I'm trying 3 to 5 cases a week. Almost every one of them, I've told my clients to do this, and every one of them on the outline or when I get the file, it's kind of compiled together, consolidated into one big PDF. But on the title page, it says expedited. That means congressional inquiry, almost every single one. And that's just getting these cases moved a lot faster. And look, I mean, it'd be nice if they could move everybody's case faster, but I look out for my clients, and you got to look out for you. So take advantage of that. I mean, again, politicians, they want success stories. And if you think about it, a congressional inquiry to get a Social Security case moved along is an easy win. They're going to have a very happy constituent. I'm sure Susan is going to be very happy with her congressperson. And, that means that could be a vote. And maybe Susan tells her family. And so that could be 5 or 6 or 10 votes. So, take advantage of that. I mean, this is what these folks are, they're there to help you. And believe it or not, they will do that. This is an easy win. It's a lot easier than, telling somebody to vote for, a bill or something that maybe goes against their party leadership. This is just something where you make a call or have somebody in their office make a call or an email. They've already got the relationships established. Just what's going on with this case. That's all they got to do. It's easy win for them. So take advantage of it is my point. And Susan did, and she got approved, and all is well. Very good. And Susan, thank you for letting us know. Wayne C. Got denied at 7 months, which again is fairly quick these days. Hired a lawyer the next day. I'm 54. They pegged me at light work. They did say I have a lot of issues that are seeing they didn't have enough information. They could fully know if I could do past work with information that they have suggested I can adjust to some work, not all. New medical evidence since the application, and finished my physical therapy coming from a surgeon about a fusion and another MRI, carpal tunnel, and opinion will come off work for a year now. Okay, so let's go back over here, Wayne. You are 54, and they limited you to light work. So basically, if you were limited to sedentary work, you meet the grid. So what's going on here is that you've got to get past two things. One is you've got to get your functional capacity by the medical to limit you to basically that you cannot even do light work, that you are more limited than sedentary, that you really can't do you can't do light work. You're basically extremely limited. And even if you could do light work, you would be at 54. You've got to meet the sedentary grid. You've got to be limited to sedentary work. So let me back up. Let me explain that more clearly. They're saying you can do light work. You've got to basically say, no, I can only do sit-down sedentary work, and you meet the grid. The other thing you have to get past, I hope I explained that correctly. So the grid rule for a person at age 54 is the 201 section, which basically says you've got to be limited to sedentary work, which is more restrictive than limiting you to light work. They're saying you can do light work. The second thing is you got to get past step 4 of the sequential evaluation process, where they have to say you cannot do your past work. So you've got to convince Social Security you cannot do past work, and then that you're limited to no more than sedentary work or no work. That's how you would win. So I've had cases denied at step 4 of the sequential process, not step 4 of the, when you log into your system there. But basically, if they decide you can do past relevant work, then you're not disabled. And you've got to prove you can't do that. Once you get beyond that, they've got to prove their Social Security got to prove there's other work for you. So what I would do is, number one, make a list of all the things you did at work, all the physical things you did, the mental things you did, all the stuff you had to do at your past work, and make sure that your lawyer knows what you did, because it's very possible that Social Security is using a definition of your past work from the Dictionary of Occupational Titles, occupationalinfo.org is where you can look that up, that is outdated. I always look at the state agency determinations, because I was looking at one today, and they had classified my client as an insurance adjuster as opposed to insurance investigator. And the difference was an investigator is out in the field doing more physical work, and adjuster is behind a computer. One is sedentary, one is light. So they decided that he was an adjuster, and therefore he could do sedentary work. But in fact, work was being done at light. And so, it was easier to prove he couldn't do that. So my point is you need to make sure that Social Security has the right definition, of the right understanding of what you did in the past. And the state agency adjudicators are notorious missing that. They're not vocational witnesses. They will sometimes decide that you have the capacity for, or that you did something a lot easier than what you did. And you want to definitely make sure that your attorney knows that. And if you're still at the administrative level, your attorney should tell the adjudicator, let's take another look at past work, because in fact you have it wrong. What you think, and now that we can see all that stuff online as attorneys, we can see what they've used, what their decisions look like. So if I'm seeing now they've made a mistake there, I'll correct that. And so I've had situations where I'm able to get the state agency to conclude can't do past work. Now it's now we're dealing with the grid rules. It just makes it a little bit easier. So definitely want to take a look at that. Don't assume that because they decided that you can do past work, they have the correct classification for past work. And the DOT, by the way, this Dictionary of Occupational Titles, last updated the 1990s. I mean, it's 30 years, 35 years out of date. There are jobs in there that do not exist. Social Security has released emergency messages saying that do not consider certain jobs. They don't exist anymore, or they are not performed the way it's described in the DOT. There's actually a whole ruling that came out where judges have to rely on more than the DOT. And there's this whole protocol now at hearings where the judge will ask the vocational witness, what sources you relied on. And they may say the DOT and selected characteristics of occupation, and they may use Job Browser Pro, which is a computer program. It's got its own issues. And the reality is, I'm just going to tell you this, the reality is there is no accurate resource out there that will really tell us how many jobs exist, for any particular job and what the standard requirements of those jobs are. However, the courts have basically said, we know this, but we're still going to let Social Security rely on outdated information supplemented by quote unquote expert testimony. And there is a school of thought, and many attorneys I know follow this very kind of hard line, that they will go after the vocational witness to at least make the argument that the information the vocational witness is putting out there at the hearing is inaccurate and should not be relied upon. It is not yet, in my opinion, it's not going to necessarily going to win your appeal, but it might be a contributing factor to that. And I think some of the attorneys who go this route are of the belief that at some point there's going to be a case that gets to the Supreme Court or maybe one of the circuit courts that does, chip away at Social Security's use of these outdated vocational sources, and that there's going to be another resource they come out to. I'm not convinced it's going to make that much of a difference because they have to rely on something, and I just don't see them basically, tossing the whole thing out. But stranger things have happened. So anyway, I personally find that if you're arguing with the VE, or the vocational expert, over job sources, you're probably losing. And I just want to win. I'm not trying to make law. And I know some judges really hate it when you go after the VE. I think there's a middle ground, and what I'm starting to do a little bit more now is I'll ask the VE, a little more information, just get them on the record to say what they relied upon. As an example, this Job Browser Pro is a computer program that basically talks about the different jobs. Well, it's proprietary. The company that makes it does not release all the source code as to what they use. So it's kind of a black box. Arguably, and then there's also this notion that they use something called SOC codes, which are, I'm not going to go into detail, but it's basically selected characteristics of occupation. Within each SOC code, there may be multiple, Dictionary of Occupational codes. So, a lot of times what they're doing is they're saying, well, there are 10, Dictionary of Occupational Titles within this one SOC code. So I'm just dividing by the numbers by 10, and that's how I come up with the numbers. Well, that's inaccurate, because what happens if, one of the job titles has 80% of the jobs, and the one that they're talking about only has 5%? If there's only 150 jobs nationally for a particular occupation and the VE cites it, arguably that's not a sufficient number to say the Social Security's met its burden to say you can return to, or there's a job you could do. I've had VEs testify, 100 jobs nationally is sufficient to decide that there are jobs that exist. Well, in a country of 350 million people, if there are 50 jobs that exist and may not be in your state, that to me is not sufficient. So again, there's a bunch of arguments that one can make. You can make to argue that the statistics are bad. There's no, in my opinion, there's no definitive way to get, to necessarily get past that, other than to, again, I think if you got 50 or 100 jobs, you could probably do that. You could argue that's not representative, good enough number. But anyway, there's some attorneys who really go real hard at the VEs. I tend not to, because I think judges don't really like it. But nevertheless, this is one of the things that is part of what we do, is we have to kind of look at, what they come up with kind of on the fly and make an argument to the judges to that this is not a sufficient number. 100 jobs nationally does not mean that that there's enough work with Social Security's met its burden to say we could find that there's a job this person can do. So I'll just leave it at that. But again, what Wayne's dealing with here is having to prove that he can't do his past work, that there's no other jobs he could do, and that's the burden of the disability case. All right, Shub 281 was found disabled August of 2023, but receiving benefits May of 2025. Award letter state of review required in 5 to 7 years. Is that from 23 to 25? It was be from 23. Go Braves. We have an ongoing thing. I think he's a Cardinals fan. The Braves. There's an article in the paper yesterday. I don't know how many of y'all follow baseball, but the beat writer for the Atlanta newspaper basically said to put a fork in it. The Braves are done this year. They've just not really. They've underperformed. Got a bunch of injuries. So it's still fun to watch, but they're not going any place this year. And Shub 281 was nice enough to leave me a tip for $20, which I really, really appreciate. Thank you. And go Cardinals. How about that? Okay. RB. Denied at recon, off to the ALJ. Okay, it's a good thing. The recon's a waste of time, so at least now you'll get a hearing in 5 or 6 months. The letter from DDS, or the state agency, listed physicians that you don't see anymore and did an inquiry with physicians you've never seen. They use the form 827 with 3 docs you've never seen. And 827 is simply a medical authorization. I have a rheumatologist specialist that's very important in my case. I don't see his name listed once. This makes no sense to me. And this is RB. This is a problem that Social Security has. Why they would send a request for medical information to a doctor you never saw, I can't explain that. The only thing I can think is that somehow your file got commingled with somebody else's file and they sent it out. Obviously, that medical provider sent back that we never saw RB. Or I've seen this happen. They sent records in and they get part of your file. It wasn't you. And I've seen this happen many times where I'm looking at a file and all of a sudden, my client's a 57-year-old male and there's records talking about a 37-year-old female. So that happens too. So I think one of the things that, as you go forward and you get access to the file, take a look at it. Don't assume that every record in there is you. It could be, another person, and that happens a good bit. The fact that they didn't get your rheumatologist, that's a little surprising, but again, not crazy surprising. What the adjudicators do is they send out requests using that 827. They send a form letter to your doctor. And they say, please send us all the medical records. We'll pay you $20. Well, many medical practices are used to dealing with the legal system, and many states allow them to charge, $15 or $20 a page. And, personal injury lawyers know this because when they request records, it could be $400 or $500. In the Social Security world, some states have rules that say if you're requesting records for a disability case, there's no charge, or it's $10 or whatever it may be. The point I'm making is that some doctors' offices and some copy services like Ciox is a big one. There's a couple other ones. They will ignore requests from Social Security because they're not getting paid anything. So you have to go to your portal and get them, or get the records yourself and upload them. That's, again, when you get to a hearing, that's one of the things your attorney needs to be doing, is we got to make sure the record is uploaded. As an aside, there was a meeting today. I'm in the 11th Circuit, which is a judicial circuit that includes Georgia and Florida and Alabama and some other places. And the head of NOSCA, which is our trade organization, he said that there's been, a real effort to get the law changed so that, on a federal level, not state by state, that people applying for Social Security disability should not have to pay for medical records. And of course, companies like Ciox, these medical copy services, are fighting it because they want to make their money. So, if you're a disability applicant, you don't have the money to pay for medical records. Clearly, the way the Social Security system is set up, when I represent a client and I get paid a percentage of past due benefits, I only get paid past due benefits. If there are file costs, there's no way to get that paid directly by Social Security. I have to rely on my client to pay it. Well, clients don't have the money. So what ends up happening is, if I had to lay out $400 or $500 for a medical record on a contingency case where my fee is capped, it starts to become a real burden on the attorneys. I've done it a few times, but I don't really like to do it. So what I rely on are the patient portals and the HIT system, the health information technology, or in those states where there's no charge or minimal charge, we do that. It has become a lot easier to get medical records than it used to be. It used to be a real hassle to do it. Now it's a lot easier, but hopefully it's going to become even easier, because I think the federal government needs to step in and recognize that, the way it's set up, the way attorneys get paid, it's no way we can lay out all kind of money for medical records, because there's no way to get paid back. And the second thing is that claimants, especially SSI claimants who may not have an attorney, or people who are pursuing, defending a continuing disability review who may not have an attorney, should they not have their case be properly adjudicated because they couldn't afford to pay for medical records? No, but we got to get that passed. And again, I think it's what the head of NOSCA said. Because the frustrating part is that they would establish relationships with people in Social Security who would be behind this, and then these folks are taking buyouts and they're resigning. So it's this constant turnover in the Social Security Administration, sort of at the higher up administrative level, that makes it really hard to get this sort of stuff done. And I think obviously right now the current administration is not going to be real sympathetic to that. The new commission doesn't seem to be all that sympathetic to it. So we'll see what happens. But again, the good news is that patient portals and health information technology are systems to let us get medical records. But to answer your question, RB, in particular, it is not that unusual to see situations where records are not part of the file. And these are important records, or rheumatologist records are really important, and that there may be requests to providers that didn't see you or saw you a long time ago. That is part of the reason why you didn't get approved. It's really important, now that you're at the hearing stage, that the judge has access to all those records. You don't want to go to a hearing and have missing records. Judges hate that, first of all. Secondly, they expect your attorney to deal with that, to make sure the records are updated. But you obviously need to make sure your attorney is aware of what is missing. But I know how frustrating it is when you look at the denial notice and you looked at the initial denial, recon denial, like, wait a minute, there are 3 doctors that I told them about, but it's missing. And the reason why is because the doctors did not respond in a timely manner to Social Security, and Social Security adjudicators don't have the time or the just the resources to follow up or to really force the issue. Michelle R. A good question. If a person has a retirement plan through Missouri Lagers and they have an early retirement disability option, will this affect the SSD process? I had a case exactly like this. It was a really unusual case on Monday. And what had happened was, my client it was Massachusetts. And basically, this is like a defined benefit program, the Lagers defined benefit program, where state employees are not contributing to Social Security, but they're contributing to their state. Well, what that means is that the person is not getting credits for the time they worked. So the date last insured could be a problem. In my client's case, she had worked for like 3 years for the state, but if you look at her earnings record on the file, I did, there's 3 years it says 0 because Social Security got no money because there's no taxes taken out. So what actually happened in my case was, my client had been insured from like 1986 through, November of 2021. And then there's this gap. Well, my client had gone back to work part-time, um, and she wasn't making a lot of money. She was making enough money to build up credits. So then her insurance picked up again. I guess her insured status became valid again in, I think it was January of 2023. So basically, I've got a gap of a couple of years, which is very unusual. Normally, when somebody doesn't have coverage, they just don't have coverage. But in her case, the coverage picked back up because the numbers were such where she started to have, within the last 10 years, she had enough credit. So what we did was we amended the onset date to her 55th birthday, which was like a month or two after her insured status became valid again, and she got approved under the grid. I mentioned that was one of the cases I had before. So it was a little bit unusual, but the real issue you've got, Michelle, and anybody who's got one of these state, benefit programs, is you're going to see zeros for Social Security earnings purposes, and that may create a problem as far as your status, insured status. This is why I tell anybody, if you're thinking about applying for disability, if you think there's not been contributions, or there's not been contributions, go to ssa.gov/myaccount and get your statement so you can see, are you insured for disability benefits. Let me ask everybody, take a second, and I put this in the comments before. We are surveying our viewers on the YouTube channel and Facebook page about different things we're sort of talking about. And I just, as a hint, some of this has to do with some AI tools where I'm putting some of what I know into an AI engine, and we're thinking about offering that, as a service to people, so that, if they don't want to hire an attorney early on, they can tap into what I know and get some answers based on my 30 years of experience. So this is what this survey is about. So if you have a second, I think it's 10 questions. If you wouldn't mind going to this website, my SSD Answers, which is my main website, /SSDanswers.com/survey, fill out the survey. It would be greatly appreciated, because it'll tell us kind of what their interest is, if any. Because, AI, as everybody knows, is a really big thing now. It's really become a huge factor. And, I'm using it more to do case analysis. Got to be really careful, because some of the free AI tools like ChatGPT, the free version, are not secure. The paid versions, you can set the security on, which I'm using and what I'm using mostly is Notebook LM, which is a Google product, and you give it the sources and that's all it has. It doesn't go to the internet. But it's a very useful tool, and that it will help me summarize the medical records, and just, if I need to know, when did my client have MRIs? I'll ask you, just talk to it. When did, Joe have MRIs? It'll tell you on these dates he had MRIs. When was he first diagnosed with type 1 diabetes? It'll tell you. So it's just a little more, it's a much more robust search function than just going to Adobe and using, the search tool for Acrobat and just go through and looking through a PDF file. This will actually tell you things. And then what it also does is I can upload to it, my website, thegridrules.net, the PALMS regulation, some other things that I've written, that kind of, some arguments I've made in previous cases, and say, well, this argument fly here, and it'll give me an answer. Now, again, I don't rely solely on that, but it's a starting point. So, my feeling is, and you probably all have heard about the crazy stories about lawyers who submit, AI generated briefs and legal arguments that have what they call hallucinations, where the AI made stuff up. I double check everything. I would never do something like that, because I think it's, it's really not, something that judges would be real happy about. But it does give you a starting point. And it'll, like I said, it'll tell you a particular page where something is, and I check it. Is it what it said it was? And sometimes I'll tell you, I check it and it's not there. It's someplace else. They get the page wrong. So you have to check it, but it's a really, really impressive tool. And I think I mentioned this before. One thing you could use ChatGPT for would be to go there if you're getting ready to go to a hearing. And I've had a number of people reach out to me and say, I'm using a non-attorney rep, or the attorney they've assigned to my case has not reached out to me. I got my hearing coming up in a couple of days. Go to ChatGPT or go to your favorite Claude or whatever engine you want, and say, what are some common questions that people get asked at Social Security disability hearings? And, you're not disclosing any confidential information, but you'll get a list of questions. And, you're not going to be asked all those questions, but at least it gives you some things to think about. I have a list of questions that I have literally open on my desktop every hearing. I go through a little checklist to make sure those are all been asked. And I've gone to Chat GPT and some of the other ones, and I'll ask that question, and I've added to my list. And again, my questions are a little more focused in some respects because I'm asking in a specific way. But if you're trying to do this, on your own, it's a great resource, a great tool. So don't hesitate to use that for that purpose. I would be careful about relying on other things, from it, and I would be really careful about uploading personal information to something unless you're very convinced that it is secure. So I think that's the big thing that attorneys have to really be very, very careful about. And I'm proceeding very, very cautiously on it. But again, if I do some sort of an AI tool, it'll be closed. And so it won't be that anybody is going to have that access to it. Okay, let's go on. My Blue Moon is 56 and a half years young. Male, I'm thinking, with severe depression, anxiety, taking antidepressants for 10 years, just insurance just approved transcranial magnetic stimulation, which is where they put like magnets on your head. Also have back, and let's see if there's anything else here. I don't see, but basically looks at some back and shoulder issues with MRIs. All right, so first of all, being 56 helps you because anybody over 50, there's a bias in favor of you. Over 55, even more so. You cannot use the grid rules for a non-physical problem. So depression and anxiety will not get you. You can't win on the grids. Now, the back and shoulder, you could. So if you have severe back and shoulder problems with MRIs that show something, you could make a grid rule argument there. But if you've got severe depression, anxiety, it seems like you are medication resistant. You've been taking antidepressants for 10 years. Now they're moving to the next step, transcranial magnetic stimulation. So, the things that would jump out at me would be, do you have a treating psychiatrist who would go on record, complete a functional capacity evaluation that would basically say that your symptoms, as well as the side effects of medications you're taking, even though they're not effective, would prevent you from being a reliable employee. And when you add to that, you have physical limitations. So let's say the physical limitations limit you to, a reduced range of light work, or maybe, light work, but with certain other limitations, no reaching overhead, things like that. When you add those things together with medication side effects, there may be enough to put you over the finish line. So, certainly being 56 helps. That's a big thing. And again, my sense would be that you've failed traditional medications, medication resistant. But I think, anytime somebody asks about a mental health case, I'm going to say, if you need to have either a narrative report or a functional capacity evaluation from your psychologist and or psychiatrist, that would make your case much, much stronger. Okay. All right, so No Sky asked about the survey, so I think we've got this in here. So again, if you have a chance to do that, that would be great. We got a bunch of them last week, and the more the better. So that'll just tell me what people want, because like I said, you got to change. You got to change with the times. And again, people are using AI, and that's cool. And so if they can tap into my brain using it, all the more power to them. That's good. Okay. A spine surgery journey. A final review from a representative is reviewing my application 9 months in. If it was denied, would they be reviewing? Yeah, they would still be reviewing. Did a form 3373, like it's a function report and a third-party report. Why did you get all this? First of all, the forms they send them out. I wouldn't take any. That wouldn't change anything in my mind. I think that many times the adjudicators just send out these forms as a matter of course. And as far as the review, they review, there's a level of review for all decisions, whether approval or denial. And so a supervisor may be looking at that. Maybe there's something the supervisor saw that the adjudicator didn't see that might have turned a denial into an approval, or you were approved by the adjudicator and the supervisor needs to make sure. So it's not uncommon for cases that have been decided to be reviewed. And this, Social Security is a very hierarchical system, so they are going to have levels of review. So that doesn't, I wouldn't make any drawing conclusions from that. I wouldn't draw any conclusions from the fact they send you a bunch of forms. I wouldn't draw any conclusions from the fact that they are saying it's being reviewed. That is just part of the normal process. But the good news is that you're going to have a decision soon, and maybe it will be an early approval. Let's hope it would be. RD from California, hello, and congratulations to Susan. Yes, Susan was the one who won early. Yes, absolutely. Congratulations and hello, RD. How long after a case goes to medical review will be approved or denied? I'd say anywhere from a few weeks to a couple of months. What's going on is that the adjudicator, who's again like an insurance claims adjuster, and they work really hard. I'm not saying anything negative there. It's just they work really hard. They're overworked and underpaid, and they work up the file. They gather the information, but they're not doctors, and so they will send it to a doctor who is under contract with Social Security, not physically there, but it's an electronic folder, and the doctor will look at it. And I look at these things all the time, and the doctor might be a pediatrician who's moonlighting, making a little extra money. It could be a psychiatrist. It could be an orthopedist. It could be an immunologist. I mean, it just depends on doctors have to make money too, and everybody used to think. I know when I was going to college back in the dark ages, people would go to medical school. They made a lot of money because doctors got paid really well. Well, what's happened over the last 30 years or so is that medicine has become a lot more corporate. A lot of doctors are working for corporations, maybe some HMOs for hospitals. They get paid a salary, and they've got huge student loans many of the time. And so it's not the lucrative type of thing it used to be. There's also a lot of doctors from overseas that have come in that will work at lower wages than American educated doctors. So, if you're a MD, and especially, if you're an MD that, finished in the middle, bottom part of your class, you still could be a very good MD, but you're not going to get, the high paying job at the high end orthopedic practice in your city. You may be working for, an HMO, or you may be working for a hospital, and you're paid, $100,000, $150,000, which again sounds like a lot of money. But if your student loans are $300,000 and you're paying out $10,000 a month in student loans, that $150,000, $200,000 sounds like a lot of money. It doesn't go very far. And I know doctors. I have my kids are in their 30s, and some of their friends went to medical school. And I know, some of these. There are a couple of one in particular. He was working for a medical practice, and he left it to do something else. He was like, I can make more money doing something else. Went to medical school, did the whole 9 yards. Got a job as a doctor, wasn't making enough money, and left to do something else. I'm not sure about his student loan situation, but nice kid, very personal. I'm sure he was a great doctor, but I think he's now moonlighting for a medical practice, but doing something else. So that's my point is that the doctors Social Security gets are usually ones trying to make a little bit extra money, and they go through these files very quickly, and you can see what they write up that they don't. If they don't know, they assume. That if you haven't gone to the doctor for something, they assume it's not a problem. So, you can get past that at a hearing, but this is the way the process works. So Social Security will send it to medical review with one of these doctors. The doctor zooms through the file, zips through it, and then comes back and offers an opinion whether the person is disabled. The state agency adjudicator will probably follow that and issue a decision. I had a case last week where the judge, after we had a hearing back in February, and after the hearing, the judge sent the file out for a review with a medical doctor what they call interrogatories. And there's a company, it's called Mednick and Associates or something like that, which basically provides expert witnesses. So they sent the file, the judge sent the file to Mednick Associates, had one of their doctors look at it. The report comes back with almost nothing on it other than the conclusion this person can work. The judge gives me an opportunity to object to it. I objected to it, basically said this is a bunch of BS. I didn't say it in those terms, but the doctor gave no explanation for his conclusions, and I want a chance to cross-examine him. Lo and behold, we get another hearing, which was last week, and they had a doctor from Mednick, a different doctor, a retired, like this guy was probably in his 80s, an orthopedist, kind of semi-retired orthopedic surgeon, very qualified, but obviously semi-retired. And he sort of said, well, you can never really tell, how pain is going to affect somebody purely in the orthopedic. I think this person could do X, Y, and Z, but I would ask them questions. Well, is the level of pain the claimant? I made a list of all the things the client had talked about, actually using AI. I put the prior hearing audio into AI, and I said, give me the summary points, which it did. So I took all of the testimony that my client had made and talked about all the symptoms she'd had. So I listed all these symptoms. I'm having trouble pushing a vacuum cleaner, trouble going upstairs, lifting a laundry basket. I can't lift 7 pounds. I need to rest after this. Just all the sort of 15 things. So I literally read those out to the doctor and said, is this inconsistent with the medical record, the orthopedic issue here? And the doctor kind of said, he goes, I can't say that it's inconsistent or not. Everybody experiences pain differently, but it would not be out of line. And so the judge basically accepted that argument and went ahead. I just got the approval a couple of days ago. So we had to go to a couple of hearings, had to go through, cross-examining medical experts and interrogatories, but we finally got what we wanted because, basically the doctors that look at the files, they're only looking at, what they can see from an MRI or something like that. They're not listening to the claimant, and the judge is listening to the claimant saying, I'm in terrible, terrible pain. This is a person under age 50, by the way. And she was very believable, had a long career beforehand. And, after had 3 surgeries that were not successful, the doctor even called it failed back syndrome or post-laminectomy syndrome. And he said, yeah, that can be extremely painful, extremely uncomfortable. And, there's really nothing that can really help this person regain function other than a multi-level fusion, and that may not work. And so where she's at right now, her level of pain is consistent with the orthopedic issues. So, we were able to win on that basis. So I go through that story just to let you know that the doctors at the state agency, the medical review, are only looking at what the record says, and they're drawing conclusions, kind of very general conclusions from what the record says, without taking into account the forms you fill out, the pain forms, the allegations of pain, the medication side effects, all the stuff that you claim. They're just kind of ignoring all that. They're just saying, well, if I don't see, 3-level herniation with nerve root compression, I'm assuming they can go ahead and work. So there's that disconnect there. And, I think the adjudicators are supposed to look at the forms. Sometimes they do, sometimes they don't. But at a hearing, that's where I have the testimony. I mentioned the form in the brief, and you kind of tie it all together. But that's why so many cases that are deserving are denied at initial and recon, is because you don't have anybody putting it all together. You just have bits and pieces, and it's like the old story about the 3 blind men and an elephant. They each feel a different part of the elephant, but they can't describe it because one's feeling the trunk, one's feeling the tail, one's feeling the legs, and they don't know what it is as a whole. And that's what happened. That's the flaw in the Social Security system. So, FL Raider fans, information for office waiting to see. If you send it in, again, I will tell you, I've been really, really tied up with hearings. Go ahead and email me directly, ssdanswers123@gmail, and let me know who you are, and I will make sure somebody gets back to you. Good evening. Rodney, and Bala is one of my clients as well, I believe. And Rodney is one of our clients. He is a regular here. Rodney had a hearing with one of the more difficult, if not the most difficult judge in the state of Georgia, and he won. And I wish I could take credit for it, but another attorney in my office, I was out of town that week. So Susan, another attorney in the office, who I'm kind of training to do this, she took the case and she won. And, Rodney got paid and all is good. So, but Rodney's been a big fan ever since. And, I guess I get a little bit of credit for it, but it wasn't me who did the hearing. I got to admit, Susan did the hearing. So, but I'm glad we won. And certainly with that judge, that's a real, real gift. Bala says, happy birthday. My birthday is on Friday. It's another year gone by. But you know what? Keep active and try to eat healthy. And, it's just a number, Glutenless Sin City. So I'm guessing you're in Las Vegas and you don't eat gluten. How's that for deductive reasoning? 100% VA permanent and total unemployability. I have 2 hearings. I've had 2 hearings for SSDI, still waiting. And again, as you all know, the VA, 100% VA rating is not binding on Social Security. Although in my hearing today, it was very interesting. I'd not seen this before. The judge asked my client, what was the VA rating based on? I've never seen that happen before. And my client, to his credit, when I originally did my brief, he says, well, you didn't really say what the VA rating was based on. I said, because it doesn't really matter. They don't really care. He goes, well, let's put it in there. I'm like, you know what? You're the client, and it's not going to hurt anything. So we put in all the factors there, with the judge, for whatever reason, didn't understand read it or not. But she asked him, and he was like, they're all orthopedic factors, is the point. And his situation here, my client had been, he had played sports in college. He had been in the military, had jumped out of airplanes, had a really, really bad back. And that was then he had a bad reaction to a vaccine. And so, the combination of the bad back, he's had multiple joint replacement. I think both shoulders replaced. He had a laminate back surgery. And again, the VA found him disabled because of his back. And the judge is going to approve that case. Again, he was over 60, so we had the grids and the POMS regulations. But my client was right that we need to put that in there. So I normally don't, but he was right. We did. So I would tell you, go ahead and put it in. Make the argument, let the judge know why you were disabled by the VA. Eunice says, welcome to Michigan. I'm not there yet. I'll be there next week in Traverse City, which I understand is right on one of the, I guess, Lake Michigan. It's supposed to be really, really nice. It is a wedding, really close friend of our family, young lady who I knew from when she was in high school. Her parents are friends with my wife and myself, and she's getting married. She actually lives in Colorado. Her fiance is from Michigan, and the young lady's from Atlanta, but for whatever reason, they decided to get married in Michigan. They don't live in Traverse City, but they live in another place, but that's where we're going. So I'm looking forward to going. I've never been up there, and I understand it's really pretty. So I'll report back when I get back. Matt says, I recently applied, you're age 50, have severe polyneuropathy, which, you know, what that means is, a lot of nerve pain. It could be in the hands, the feet, elbows, can be in any joints, inflammatory arthritis in the back with an MRI, maybe like psoriatic arthritis or rheumatoid arthritis, anxiety with panic attacks, degenerative disc disease, attended physical therapy several times. Again, there's an orthopedic component here, an exertional limitation component here. So I would tell you, look at the grid rules. And again, if you're 50 and you could be limited to sit down or sedentary work and no transferable skills, you can win on that. You can also argue that there's no work. You wouldn't be reliable because you'd miss too many days from work. Now, you mentioned you attended PT several times. I think that, if you're dealing with back issues generally, you need to be seen by an orthopedic surgeon, a neurosurgeon, and at least have an opinion as to whether you're a surgical candidate or a candidate for pain management. That's kind of the level of impairment you have to have. Just having a bulging disc or two is probably not going to be enough. And the polyneuropathy, that can be measured by something called a nerve conduction study or an EMG. There's different tests for that, which can show, if it's severe, it can show, the level of how bad it is. That's objective evidence. So again, 50 is better than 48, but it's not as good as 55. So you still want to show you've got a severe level of impairment that's going to really, really limit you from even a simple sit-down type of job. Okay. Maureen Shannon, good evening. And many folks, yes, good evening, Maureen. I'm glad you tuned in. Good to see you. Thank you very much. Mr. Donnie Doomsday, that sounds negative. I don't know, Donnie Doomsday, but okay. On reconsideration since February, I submitted medical records then from spinal stenosis and other ailments. Is a long processing time for that good? 35, nerve root impingement, stenosis. I mean, 35 is going to be a problem. I'm just flat out tell you that's a problem. Long processing time, don't draw any conclusions about that. It could be they're backed up. It could be just they get trouble getting medical records. Short processing, long processing doesn't mean a darn thing. I think that, again, the real issue here is at 35, you've got to have, a level of impairment that is going to prevent you from doing any kind of work. And literally, I mean, a warm body, fog a mirror type of job. You're sitting at a job and you're taking, yellow highlighters and you're putting them in a box. That's what you're doing. Or you're monitoring a textile, line to make sure that, the socks coming off are not mismatched or something. I mean, just, really, I got this video, I got to find it, of a guy like sitting there looking at an assembly line, just doing nothing. I mean, that's really the level of impairment you got. So at 35, it's a real uphill battle. But if you've got significant, pain medications that make you drowsy or falling asleep, if you've got severe, nerve issues with your back, the stenosis is causing, numbness, tingling. I would even say the level of, where you can't feel your feet or you're having trouble with bowel or bladder issues, that level of impairment, you could possibly get over the age thing, but it's got to be pretty bad. Got to be pretty bad at 35. But the processing time has nothing to do with it. Lulu is 61. Let's see. Partial proof 52-month difference. Okay. What I'm sensing you're saying to me, Lulu, is that you were approved, but for a date after your insurance ran out. And, or that there's or that you got approved a partially favorable decision, but they cut out 52 months of past due benefits, which could be, $50,000, $100,000. Well, and in fact, I'm going through a bunch of cases now where I got approved, my clients approved at initial recon, and I'm writing each one of them saying I'm doing the analysis. Should you appeal it? Some of them will do it, some of them won't. My feeling is that as a rule, if you're looking at a $10,000 haircut or less, probably don't want to appeal it, because realize when you appeal it, everything is going to be on the table. So the appeals council could send it back to a judge and the judge could deny you. It could go to a different judge. And even though you got a partially favorable from Judge A, that Judge A may retire and now goes back to Judge B, who's got a very low approval rate. There is risk. I wouldn't say it's a huge risk, but it is a risk. So, for 10,000, 8,000, 5,000, probably not worth it. 30, 40, 50,000, it could be worth it. Now, one thing you have to keep in mind is that you can only get paid 1 year prior to the date of application. So let's say that you applied in 2024, March of 24, the earliest you get paid is March of 23. Even if you were found disabled in 2020, you're not going to get all those years. You only get that 1 year prior to the application. So I've had situations where I had one, in fact, there's a young lady who is on here a good bit. I'm not going to say her name, but she got approved. And basically they changed the onset date by like 2.5 years. However, when I ran the numbers based on when she applied, it made zero difference. So whether she was approved as of March of 23 or March of 21, it didn't make a difference, because when you looked at 1 year prior to her application, the money was going to be exactly the same, and she was still within her date last insured. So I said to her, look, we could appeal it, but you're taking a risk for no reason at all. Just let it go, because it's not going to change the dollars at all. In her case, and so she agreed, and we didn't do it. But I've had cases where I had a couple of them this year where it was like a $30,000 difference. We appealed it. We went back to the judge. Boom, we won. And person got that extra money. I have one right now where my client got approved, but a partially favorable, and she's really, really hot about it. She's like, this is ridiculous. They just changed this very arbitrarily. And, I sent it to Carl Osterhout, who's one of my go-tos. And he's like, don't appeal it. I'm sending it to somebody else now to see what that person says. It's just a judgment call. So I tell my clients, says, look, there's risk here. You got to make that decision. If you want to appeal it, we'll appeal it, but that's your decision. But you got to really think about that. But don't forget to look at the application date, not just the onset date, because you have to really do the numbers analysis there. Cindy G says, good information. Thank you, Cindy G. Much appreciated. And I'm going to put this up here now. For those of you who are so inclined, leave me a review. I've gotten some really, really nice reviews. Whenever I win a case, I ask my clients to leave me a review. At the time, I let them know that they won. So I've gotten some really good reviews. I'm on kind of a winning, I shouldn't say me, all my staff. It's not just me. It's Jen, it's Kayana, Madeline, Darlene. There's a bunch of them in my staff, and they're all responsible. Stephanie, and Angela now is a new person. They're all responsible for us winning these cases. So it's not just me, but we are on a winning streak. So always like that. That's always a good thing. Last question. Can you get your monthly check while you appeal? Yes. Once if you appeal the partially favorable decision, I always wait till the check, you have 60 days to file that appeal. I wait until the check starts coming, then I file the appeal. When I've done it that way, the client continues to get their check. The risk again is if the appeal is sent back to the judge and they get denied, now you may have 2 or 3 years of overpayment. And Social Security will say, we want our money back. And again, you can appeal that as well. But, if you end up losing, then you have an overpayment, which you can discharge in bankruptcy, but you still, that's a risk that you could lose, your ongoing benefits. You could owe them a bunch of money, have to file bankruptcy on it, and then you're basically not getting anything. Whereas if you accepted the changed onset date, you get your ongoing benefits, but not as much of a lump sum. That's really the question. Matt F. And Matt was earlier. He's age 50. Just to go back over here, severe polyneuropathy. And he said he's using a rollator to ambulate. Doctor's going to order elbow canes. Tried part-time, still difficult. Yeah, I mean, if you're using what they call an assistive device, a rollator, if you don't know what that is, it's like looks like a walker, but it's got a seat on it. My mom, when she was in her 90s, she got one of those. It's got little brakes on it, and you basically use it to kind of walk to keep your balance. By definition, if you're using a walker or rollator, then you cannot do light work because your hands are basically tied up with a rollator. So that says to me that you are going to be limited to no more than sedentary work at age 50. You grid out, assuming no transferable skills. And if you have pain with polyneuropathy, I'm sure you do, medication side effects, if you're a Neurontin or a gabapentin, can give you GABA brain. I think you've got a really strong argument based on what you're telling me to look at the sedentary grids and make the argument that you are disabled under grid rule 201 point whatever, based on the fact that you have a prescribed assistive device to ambulate. So I think that would be a good case there. Okay, Vince. All right, Vince says Vince is in Michigan, coming to his home state. I always give when it was cold. Vince is one of my clients, and I was giving him a hard time about the cold weather when it was 30 degrees there and 75 degrees here. A lot of cool stuff to see in Traverse City. I'm a photographer. In fact, I'll show you my camera here. This is my sports camera. I have a big old Nikon with a big old zoom lens. I'm not taking this with me, but I'm a pretty avid photographer, so I've got a couple of smaller cameras, but I'm going to take that with me and hopefully get some nice landscape shots and some nice shots of different things. I love taking pictures of different places. It's just, it's always been kind of sort of my thing. So looking forward to that. But I need to actually put some of my pictures up there or put them on a site where I can let everybody see them, because I've got some neat stuff out there. I need Darlene to call me tomorrow. Okay, well, email. Darlene's very good about replying to things. Darlene and Angela are my call screeners at this point. Madeline's on kind of a summer break. But just reach out to, if you've got Darlene, you probably have her email address. Just reach out to her and to Angela, and they will definitely do it. Amelia Brown, congratulations. I'm not sure if she's saying congratulations to Susan Schmidt or whomever, to me for still being alive after all these years. I don't know. I'll take it. Miracle after miracle. No trace of back pay. This is Sharon, is one of my clients that we got an approval, but we are having a hell of a time getting her paid. For some reason, they are just really slow. In fact, this was a topic for the NOSCR 11th Circuit meeting today, where there's a lot of people having trouble getting paid. And the problem is that there's not enough people in the payment center. They used to have phone numbers. They've taken those offline. We don't know how to get a hold of them. So what we're being told to do is reach out to the regional chief judge. In fact, I had a conversation. I'll just tell you, since you're here. We were talking. Jen and I were talking that Stephanie is one of my staff people who does a lot of our appeals, but she's also the person who checks on fees. And so we made a list of all of our cases where we have not gotten, our clients hadn't gotten paid or we hadn't gotten paid. And because we have a little bit of a gap, we don't have a lot of hearings. We have a gap of a few weeks before we kind of gear back up. So we're going to spend the next 2 or 3 weeks focusing on, collecting the money that our clients need. So we're on it. We're not. I believe me. I know how frustrating it is. Again, not that it matters to you, but I mean, I've got lots and lots of money out there that I've not gotten paid on. Some of my clients have, some of them they have not. I have a crazy one where the judge denied my fee contract, unknown reason why. I wrote the regional chief judge, who wrote a letter saying, pay Ginsberg. So they sent me half the money. I can't get anybody. I've written a bunch of letters. I can't get so stuff like that. So we're on it. But Sharon, we're not going to forget you. We will definitely get you paid. Once you get your date less insured, how long does it last before you're not insured? Generally speaking, your insured status will follow you for about 5 years after you stop working, generally. Because remember, you have to have 20 quarters or 20 credits. I'm clear on that, 20 credits in the last 40 quarters. And so you earn up to 4 credits, and to get a credits, around, I think I have the number on my website, it's around $1,900. So basically, if you make $8,000 a year, you get all 4 credits for the year. So you can get, if you have basically 20 credits in 40 quarters, which is 5 out of 10 years. If you work for 5 out of the last 10 years, you'll be insured. If you work for 10 of the last 10 years, then logically your status will follow you for 5 years thereafter. So normally, if you're working full time and you stop in March of 2023, your insured status will follow you till March of 28. That's generally how it works. But and that's one thing I wish they would do on the my Social Security statement. They don't do it, but I can do the calculation manually. If you get your statement, I can look at it and tell you approximately when your date last insured is. It will say on the statement you have enough credits for disability insurance, but it doesn't tell you when it runs out. When I'm actually in the file, I will look at a file and I can see exhibit in the D section of the exhibit. It will tell me the date last insured, which many times, by the way, is different from what the summary page says. So the judges rely on the date last insured in the actual file. So once I've got a file, I can tell you, but Before then, you really can't. It's just crazy. Vincent Costanzo received an update from SSDI appeal. Step 4, my claim was the local office for non-medical review. Is this good, bad, or unknown as being approved? Assume medical review was approved prior. Non-medical review generally means they're looking to make sure you don't have any earnings after onset, which would suggest an approval. I just hate to tell somebody that's absolutely what it means, because I just don't have a lot of confidence that, what they're telling you about where your case is at is entirely accurate. If it is, and your non-medical review, that's probably a good sign. I'll leave it at that. But don't be shocked if for some reason that's not the reality. Probably is, but you never know. I have assets, says Emery, and in July 2024 had a failed fusion. Okay, I know what I'm saying, but I guess upset someone from filing disabilities, assets are limited. Should I take assets start this? I'm not sure what you mean. I mean, if you are a disability, if you have enough credits for SSDI, and you file for disability, it could be as quick as 5 or 6 months. It could be 2 or 2.5 years. If what I'm thinking you're asking me is what am I supposed to do? Do I have to use up all my money? In a disability case, having assets, having retirement money or having money in the bank does not prevent you from getting disability. It would affect your SSI, but not for disability if you're insured. But, nobody wants to go through their retirement money or their savings waiting for Social Security to hopefully approve them. Unfortunately, there is no other option, because again, if you apply and you're working, you can't do that. You have to be, you have to be working less than SGA. So, many people end up going through everything they own, lose their house, sleeping in their car, waiting for Social Security to pay them. And then they eventually get paid and they get a lump sum of $40,000, $50,000, $60,000. But then they say, well, I had 150 in my retirement plan. That's gone. This is one of the big flaws in the disability system. It takes a really, really long time. And even a strong case, a failed neck case, is clear as that is to you and me, they may not approve it. Hopefully they will, but I think, there's absolutely there's no guarantee they will. I mean, I'm winning, like I said, I'm winning all these cases at hearings in the last few weeks. Every one of them was denied twice. And like I said, the ones today, I mean, I literally didn't say anything. When the judge is like, okay, I've heard enough. I looked at the brief. I've heard enough. You win. Why weren't those cases approved early? They should have been. I mean, failed, the one I had the other day, failed back syndrome, 3 back surgeries in 1 year, then an epidural, nothing helped. And then, spinal cord stimulator didn't work. Medications didn't work. Why was this lady not approved a long time ago? Can't answer it. That's just what it is. But yeah, Emery, I think the problem is you may very well find yourself going through your assets waiting for this process. It really is frustrating. Renishi Killingsworth got me a denial letter July 4th. You have 60 days to appeal. So you definitely want to file an appeal either on your own or with an attorney. I think that, getting an appeal filed sooner rather than later is not a bad thing. The only thing I would caution you about doing it on your own would be, you want to make sure that when you do the appeal, that if there's something new going on, that you put that in the appeal. You don't want to wait till the hearing and bring, oh, by the way, I've been diagnosed with knee problems and it's never mentioned before. That's not a good thing. And you want to look at what they relied upon to deny you and make sure that the records that were missing are referenced very clearly on your appeal. And again, I would tell you, if you are over 50 and you've got an exertional problem, a physical limitation, make the grid rule argument in the remarks section. If somebody files the appeal at recon, they're probably not going to win, but you never know. And you can always wait until that recon denial and then get an attorney to do the hearing. It's up to you. Some people like to get the attorney involved early. Some want to give it a shot on their own, and that's all cool. But yeah, get the appeal filed one way or the other. No reason to wait until if you got denied and the letter was received, look at the date of the letter, add 65 days to that. That's really what you need to be focused on. No reason to wait until September to file it. Go ahead and file it sooner rather than later. Wenda Bush, my appeal was December 8th of 23. I'm still waiting. I'm 55. Okay, that is too long. I'm just telling you, that's just too long. You need to contact your U.S. Senator's office to find out what's going on. Is it possible they denied you and didn't send you a letter? That is possible. But, you've been waiting for well over 2 years. What is it? That's 23 to 24. A year, almost over a year and a half. Way too long. Way too long. You got to reach out to a political, representative and find out what's going on. I don't know how. Would you please send me a link? Living in North Virginia. I don't know, Chan, what you're asking. What kind of link? I don't know what you're asking about. I'm sorry. You're saying send me the link, but don't know what you're asking. If you could rephrase that. The Dreamers Club has emphysema on 2/24. And filled with the function report. No fumes, 54 from home for the past 5 years. Again, if you are less than 10 pounds lifting, standing walk for less than 2, that's sedentary. So, yeah, if you have a sedentary RFC, a residual functional capacity, and you are 54, and you have obviously limits as far as, dust, fumes, gases, you've been working at home, I think you win. I think the grid rules would apply here. So severe lung disease, breathing, I think that's a grid rule that just sounds like grid rule to me. So I think that's what I would look at, the sedentary grid. If you've got this functional capacity statement from your doctor, that looks good to me. An initial recon, they said I couldn't do past work, but felt I could do something. Well, the judge sees these comments and the comments made initial recon. It will be as part of your record, correct? But as the judge will tell you at the hearing, this is a de novo review. The judge will specifically say, I am not bound by the decisions made at initial and recon. So you'll get a completely new look. Now, when I do a brief, I will look at what the initial and recon adjudicators say, and I will specifically say it. Recon, if it's helpful to me, the adjudicator found my client could not do past work. So I'll mention that if that's what they said. If the recon or the initial adjudicator says the person is limited to light work, I'll say that's our starting point. So that's what I do. This is the starting point. However, we disagree. We think that the adjudicator, did not consider all the factors, and in fact, my client's limitations are more than what they said. But I use it as a starting point, so that I don't want a judge to, even though the judge can basically say I can do anything I want to put a little pressure on saying, look, your own agency said this person's limited to light. You're going to now find they can do medium, or they're limited to they can't do past work, and now you're saying they can. So I think that that's something I would address. But yeah, the judge will see it, but it's not binding on the judge. How does the big beautiful bill affect having to pay taxes at 85%? I haven't read it yet. We're still waiting for NASCAR. I know we're starting to see dribs and drabs come out about what the effect of Social Security is. It's still a little too early for me to know. I just haven't, honestly, I have not had time this past week to go through it. That information will be coming out in the next couple of weeks. I know, and by the way, I mentioned this earlier, there will not be a live stream next week because I'm going to be out of town in Traverse City, Michigan. I'll be back on, I think it's the 23rd, which is a week from next Wednesday. And hopefully by then I will have information about the big, beautiful bill and what that meant in terms of Social Security and taxes. All right, Emery this is the person who had come here before, or asked me a question before with the assets. Failed neck fusion plus anxiety, bipolar pain before suicide. No, you will not be. Now for SSI, you cannot have assets beyond like a couple $1,000s. And if you're getting Medicaid, Medicaid is associated with SSI, Medicare with SSDI. So if you're pursuing SSI and Medicaid, yes, you cannot have those assets. Now, you said sell those assets. Now, I will tell you that there is a whole subset of law about qualifying for Medicaid and asset protection and asset distribution, things like that. It is well beyond what I know. But I know that there are elder law attorneys who do a lot of work in this area where they're trying to get people qualified for a Medicaid bed. And that person may have, let's say they have real estate that they own. What can they do about it? They have retirement money. What can they do about it and still qualify for Medicaid? I know that Medicaid, that's the tennis. That I played 2 hours today. But Medicaid, I know, is really, really cracked down on people trying to manipulate the system to get rid of their assets. So I would not just assume anything. I would probably find somebody who can give you advice on that if, in fact, you are pursuing Medicaid and SSI. If that's what you're doing, Emery, I don't know. Tom says, is it a good idea to get my doctor to file an RFC form? Yes, absolutely. And I don't like to call them RFC forms. RFC stands for residual functional capacity. It is a legal term, but if your doctor will fill out a functional capacity form, that would be very, very helpful. How to find out if your ALJ will bring a medical expert to the hearing. It'll typically be in the hearing notice. Every once in a while, I'll go to a hearing and there'll be an ME there that I was not expecting, but normally they're theoretically supposed to give you notice, and the resume of the ME and the VE are supposed to be in the file. So arguably, and I've never done this, but arguably, if I got to a hearing and there was an ME that had been put into the file the day before, and I didn't have time to review his or her resume, I could ask for a reset hearing or object to the ME. Now, I'm not going to do that because I don't want to PO the judge, but arguably you're supposed to know, and it should be in the hearing notice. That's usually what it is. I'd say 99% of the time that's what's going to happen. Okay, the captain says the ladder of the law has no top and no bottom. The legal system is always biased to keep the lords in power and the serfs down. Yeah, I'm not going to disagree with you. I think that, a lot of areas of law, this being one of them, is unduly complicated. You shouldn't really have to, I'll just kind of flat say, should you really have to pay a lawyer to prove you're disabled? It's gotten so complicated that now you have to know about forms and legal arguments and functional capacity and grid rules and listings. And yeah, it is. And date last insured and date first insured and, like residual functional capacity and vocational witness testimony. It's gotten really, really complicated. And it's the same thing filling out a tax return. I mean, why should tax returns be 100 pages? All the special interests get involved in them. And I think they keep changing the rules. They keep moving the goalposts. They changed the look back for past work from 15 years to 5 years. Well, that could make a big difference. They changed the vocational, requirements for vocational testimony. Legal stuff is complicated. It shouldn't be, but it is. And unfortunately, I wouldn't go to a hearing without an attorney, and I understand when people get upset that they have to pay 25% of their past due benefits, and nobody's putting a gun to their head to do it. But 100% of nothing is nothing. 75% of $30,000, and it's capped at $9,000, by the way. So it's never going to be. So like 25% of $27,000. Yeah, it's a lot of money, but it's better than having no money. So it is. It's just it is. But I think you could make an argument that unfortunately, the justice system, the legal system is, it is designed by lawyers. Most legislators are lawyers to, give lawyers work. I mean, I'll just flat out say it. That's probably what it is. I don't think that's what they sit there and think, but they make stuff overly complicated where that's what ends up happening. So, Yeah, it's a challenge. It's definitely a challenge. I mean, I will tell you, people say to me, what do you, what's, should I go to law school? And what do you learn in law school? And honestly, what I learned in law school was there are different areas of law out there. There's something called torts, which is like personal injury. There's criminal, there's constitutional law, there's wills and estates, all this stuff. You learn what's out there. You learn, how to do research and how to look up stuff and find, you know, if you're making an argument, how to make that argument. But the most important thing is you learn how to think like a lawyer. And that is, you know, every argument that you put out there, there's a counter argument to. And you have to understand, people get very upset. How could the judge make that? Well, because the judge had a different vision in his or her mind about what it means to be disabled. And what a lawyer will do is look at this without any personal, stake in it. They want to look at it and say, what argument can I make to make this a winning case? I've had conversations with clients where I'll say, look, you need to consider changing the onset date, because I know from 30 years of experience that, when you're 54, you're not going to win. But at 55, you meet the grid rule. And I know this judge, and this is what I think you need to do. I'm not telling you have to, but I think that's what's likely going to happen. And I'm usually correct about that. So yeah, there is value. A lawyer can bring perspective to it and can hopefully give you good advice about what to do. So I don't know it's about so much of keeping you down, but it certainly is complicated to the point where, the law is, you need specialists. And I think this is, look, you wouldn't, car mechanic, why should you have to pay $800 for a pair of for replacement brakes when the brakes themselves were $100 and the labor is $700? Well, it's just because you can't do it yourself. Same sort of thing. All right, enough of the soapbox there. Okay. Sam the Man. Had my hearing yesterday. My attorney thinks I was approved since you're 61 and my job title was originally classified as light, so will approve the requirement to lift 80. Okay, so this is another example of a job that was classified as light in the DOT, but in fact was very heavy in real life. And so you're 61, that gives you a real advantage. You can't do past work. There's no transferable skills. Boom, you win. So I think that's great. Sam, you're welcome. All right, No Sky asked for me to remind you to take the survey. Let me put that banner up here. Oops, this is the wrong banner. Wrong banner there. Okay, let's do the survey here. Yeah, please do that if you could. Just tells me kind of what people are interested in. Let's see what we got here. I don't know if you received your answer, but the EOD, established onset date, is 25. So, okay, so I think what Shib was asking was, if the review is supposed to be 3 to 5 years, is it from the date of payment or is it from the date of onset? I think it's from the date of onset, not from the date of payment. If you are paid, realize there's a 5-month waiting period. There may be delays in getting you paid for whatever reason, but you look at the date you were deemed disabled, the onset date, and if it's a 3-year or 5-year review, although those are very loosey-goosey numbers, I think it's from the date of onset, not the date of payment. Emery says, I have severe migraines that cause anxiety, major depression disorder. They sent him to a consultative for pain. I was recommended to see a neurologist the night before the exam with neurology was done. And so what Emery is basically saying here is that, his claim is based on, depression. It's based on, some pain issues. And the CE doctor, I'm guessing, says he needs to see a neurologist for maybe migraine headaches. And that was in the report, but before that could be acted upon, he was denied. Realize that the adjudicators are not bound by what the CE doctor says or what any doctor says. So if your doctor or a CE doctor says you really need to see a cardiologist or a rheumatologist or a neurologist, the adjudicator has final say about that. You can go, obviously, on your own, but they may not keep your case open for that. So that's what's going on there, I think. Mr. P was denied SSI last year. Gone over to appeals judge. I'm assuming the ALJ. Well, they used the same exams for my first application. All the examiners said it was disabled and had marked limitations. Well, let me try to answer it this way. If you reapply and let's say you were denied at a hearing in 2024 and you go to the appeal and the appeal is denied and you don't appeal it further, you can't find someone else takes it to federal court and you reapply, the earliest onset date you can claim is the day after the unfavorable decision in your prior case, because everything before the day of that decision is called res judicata. It's been decided. So those documents will be in your file, but a judge is not going to find you disabled prior to the denial date of the last ALJ hearing because it's already been decided. It can be relevant. It shows, ongoing problems, but a judge is not going to go back and reopen your prior hearing and decide that you were disabled back in 2022 or 23. That's already been decided. The earliest onset date you can do is the day after your unfavorable decision in 24. This is Life says the first CVR for chronic fatigue syndrome and anxiety and depression already submitted RFCs, marked limitations, 10% off task. New note says can't focus 30 minutes, severe. PEM recommends neuropsych. Submit or skip. I would submit. I think that's very helpful information. I would submit it. I don't see a reason to skip it. Get it all in. It's going to help you. RB says, thank you for what you do. You're welcome, RB. I'm pleased to do it. Already the RSC form. Good. Can you work making 10 hours, only working 32 hours a week, $10 an hour? Well, let's do the math. 32 hours times 10, it's obviously 320, times 4, that's 1,280, that's below SGA. So 320 times 5, if you have 5 months, 1,600, that's below SGA. So if you're making $10 an hour, you're working 32 hours a week, by my math, and I'm not a math expert, you're below SGA. Even in those months where you have 5 pay periods, you're still below SGA. Now, if I was in your shoes and you're working part-time, I'm not a big fan of ongoing part-time work right up against the SGA limit. If SGA is 1,620 and you're earning 1,600, that kind of looks like you're sort of manipulating the system. I kind of like to keep those earnings in that $1,500, $1,400 territory. But if you have to eat, you got to eat. But yeah, you can work part-time. Now, there are some judges who are going to look at it and say, well, if you could work part-time, then, why can't you work a little bit more and get over the SGA limit? So, that's the issue you run into. But, if you have to eat, you got to eat. Captain Solar, Souls the Devil. What is my AI of choice? I'm in a mastermind group right now that's studying Chat GPT, but the paid version, the Teams version, which is the paid version. And that's got a little bit more power. I use Notebook LM a good bit because it's very contained and it does not, excuse me, it's designed not to hallucinate. So I feel very comfortable with that. The Microsoft product, I'm drawing a blank on it here. I just looked at that today. Is Copilot. Microsoft Copilot is very powerful. I don't know much about that one. I'm going to look into that a little bit as well. I've looked at Claude. I think that's pretty good. I would say Notebook LM right now is the one I use the most. With the paid Chat GPT, I'm using that more for coming up with ideas for videos or, just sort of brainstorming things. Not quite ready to use it for case prep. I'm still using Notebook LM for case prep. I'm still kind of doing my due diligence on confidentiality because that really concerns me. I feel pretty good about Notebook LM, the paid version, because it's contained. But that's what I'm using. This is life. Are the same people who review medical expert before approval the same ones that reviewed during a CDR and still 95% right under Trump for CDRs? I have not seen any statistics about CDR, where they keep things as they are, I think is what you're asking. It's the same office. I mean, it's the same level of person. It's just the people who do CDRs may be different than the people who do initial and recon. I don't know if they have more or less experience, but it's the same people. It may not be the same. The person who does CDRs may not be the person who also does the other, but there may be some interchangeability, but it's the same level of person, I would think. Okay, I'm not sure what that is. Have a hearing in September, recently diagnosed with a 360-degree labrum tear on your shoulder. Should I schedule my operation before or after the hearing? I get that question a lot from my clients. I don't ever like to make medical decisions based on what may or may not happen in a Social Security case. It looks like my I'm getting an error message with my video here, so I hope you can still hear me. Hope you can still hear me because I was getting an error message there. Anyway, I don't like to make medical decisions based on Social Security. I would say do what's right for you medically. If you have the hearing or if you have the surgery, then you have the hearing, you're still going to be in recovery. So I would say get the surgery done. My personal thought is if somebody's going to do surgery, get it done, get it out of the way, just do it. But I don't think there's a strategic benefit one way or the other, because again, if you have the surgery and it's successful, that may make you a candidate for a closed period, but you may have less success if you wait, because the longer you have things not dealt with, the harder it is to fix them. If you go to the hearing without the surgery, they're not going to hold it against you if you couldn't have the surgery. And obviously you're going to be more disabled not having had the surgery. But I still come back to, I don't like to make medical decisions based on Social Security. Okay, you can still hear. Okay, so can you see me now? I hope you're back to being able to see me here. Let me go ahead and remove the. Okay, let's see if I hope that you can see me again, because I somehow I get on my webcam, it's got a little green light, and when it goes yellow or red, it means there's a problem. So it went yellow and red there. The VA is lenient in comparison to SSI. Well, the VA realized that the VA will look at percentages of disability, not just all or nothing. So you could be 35 or 30% disabled or 50% by the VA, where Social Security, either you're disabled or you're not. So it's not about being more lenient, it's just different standards. Ms. B, good evening. It's been a 7-month waiting period. Just received an update by the wage request. Been at stage 3. Does this mean my medical review has been completed? Probably getting close to that. 7 months, I'd say you're probably getting pretty close to that. I think so. And hopefully that you'll get a decision soon. Elliot, I'm legally blind and 33 years old, about to resume school for my bachelor's degree. This triggers CDR. Haven't had one since years ago, qualified 10 plus years ago. They may not realize that you're going back to school for your bachelor's degree. I'm assuming if you're legally blind, you're going to have special accommodations. So I would certainly keep track of that. If they do a CDR and they ask you, what have you been doing? And you say, I went to school and got a bachelor's degree, that could be problematic. But if you have significant accommodations, then it may not be as big of a deal. The fact you haven't had one in 10 years or you haven't had one since a few years ago after you qualified 10 years ago, that's a good sign. That probably means you won't have them, because blindness doesn't really go away. But yeah, anytime you take on something like school and they find out about it and they review you, they could decide that means there's medical improvement. So it could, I don't think it'll trigger one. It's not like they're going to be getting any word from the school, but if they do a review and they ask you what has changed and they discover you've gone to school for a bachelor's degree, yeah, that could be an issue. DG says, thank you for the work you do. Well, you're very welcome, DG. I am happy to do it. I have a good time with this, and it is it's something that's I've had a good, really, actually, a very good time with. In fact, I was talking to a gentleman named Spencer Bishens, and Spencer used to work with Social Security. He wrote a book about the Social Security process and kind of how to work through it. He's going to be on, I think, on the 30th. And he's been gone from the agency for a couple of years. We're going to talk about what he did in, working as a writer for judges and some of the stuff he saw, from that end. And so it'll be really interesting. I interviewed him for my podcast a few years ago, but I'm interested to see what he has to say. Vince says, when I'm in Traverse City, go to Sleeping Bear, Sand Dunes, or Mackinac Island. There's casinos. I'm not a gambler. I never had, just doesn't do anything for me at all. But Mackinac Island, the Sleeping Bear, Sand Dunes. Yeah, I'm going to start researching it to find out what things I can do. But thanks for the tip. When you go for recon, does your attorney write a brief? You can. I sometimes will write a mini brief. It just depends on. Actually, up until recently, I didn't have access to all the medical information. Now I do. So I'm starting to do more of that. If I haven't, in fact, I'll just tell you what I'm doing is we're putting that medical information into our, let's say, notebook LM, and using that to do a summary, and then I'm able to write the brief a lot faster. So I am doing more of that. I know my office has been a real pioneer with that. She's a big fan of just making those arguments early. We're one of the things I'm kind of rolling out, I call it Operation Early Approval, because I want to get these cases approved early. And that's part of what we're doing, is doing a little more work at being a little more formal in terms of asking the adjudicators to approve it early, because I want to get them approved early. Don't give me some Moomer's homemade. Well, that, Vince, I promise you, ice cream is something I am a connoisseur of. Love ice cream. Love ice cream. Moomer's. Okay, I'll make note of that. Moomer's ice cream. Where's the thumbs up? You're asking about Christina. Normally is there. So Christina's not here tonight for some reason, but she's always saying, give it a like, give it a thumbs up. So if you don't mind, if you have a chance to give it a like, give it a thumbs up, please do that. That would be great. Robin Myers, a 56-year-old dental hygienist with both thumbs fused and closed. Would I get disability? Well, I think that, clearly you can't use your hands for vocational purposes. The question is, I would think, and I'm just going off the top of my head, but I can't imagine there are too many light jobs you could do without use of the hands. Now, again, your thumbs are fused, so that means you can't really do any gripping. Are you able to do any pushing, anything like that? Is there any vocational use of the hands at all? If you've got a doctor that says you have no vocational use of your hands, you obviously can't go to anything doing dental hygienist work. I think you're limited to no more than, certainly you can't do light work, right? Because light work, I think, you have to be able to lift 10 pounds, 20 pounds on occasion. I think if you have evidence that you can't lift really more than a couple of pounds, you have no functional use of your hands, I think it's a winner. That would be my thought. Hit it. I think you mean hit the like and subscribe and all that stuff. Yes, please. SS office told me I was approved for partially favorable, not fully, partially. How long does it take for the back payment? Normally it takes about 2 or 3 weeks. What is GABA brain? Kelly asked. That is gabapentin, or Neurontin, is a medication that is used to control nerve pain. It's different than opioids that might be used to control, just back pain, orthopedic pain. This is more nerve pain, that kind of electric shock pain. And it can help a little bit, but gabapentin is known, or Neurontin is known, for causing really fuzzy thinking, and they call it GABA brain. Many people, not everybody, but many people get what they call GABA brain, where they just can't focus and think, and they're like a zombie. And so if you're on high dosage of gabapentin, that is one of the side effects of it. Okay, Vince says, get really nice photos. We're going to Mackinac Island, picture rocks. Okay, I'm not sure how much time we're going to have. We'll have a rental car. I know we have a couple of days. We're going to have a little bit of time, so I will definitely look into that. And I'm sure I'll get some nice pictures. Of course, my wife is going to be with me, so she wants to do stuff too. But I'm going to definitely take I'm going to take a decent camera, so hopefully I'll get some good shots, and I'll share them. GG. 54 been suffering post-concussion issues, cognitive auditory issues, pressure in head, also vision issues as well, back injury, restrictions from ortho, head injury, stopped working 2 years ago, RC your past job, and can't do it. Again, the post-concussion issues, the TBI, closed head injury, is probably not going to limit you orthopedically, but the back issues might. Yeah, I think that if you've got a neurologist or somebody that's going to say that you have problems cognitively or you have terrible headaches, that's a pretty good argument. I mean, significant post-concussion injuries can cause personality change. They can cause difficulty thinking, pace of work, emotional stability, all these things. You got to just really flesh out the symptoms. But yeah, I think those can be good cases. T-Cash, great show. Thank you. When did SSI turn to crap, needing an attorney, word of doctor, unbelievably well pay into it? Well, I think, I've been doing this for 30 years. I know people who did it before then. Like a lot of areas, once they make it where attorneys can get paid, their attorneys are going to get involved in it. Now, I'll give you an example. Federal workers' comp is an area where people who work for the federal government, the post office, the federal government, they get injured. They have to file a federal workers' comp claim. It is almost impossible to get paid as an attorney. So very, very few people do it. There are ways to do it, but it takes a long, long time. However, you would think, well, does that mean that you can do your federal workers' comp case on your own? It doesn't make it any less complicated. I mean, I just think that, Congress, their job is to write laws, and they just make them complicated. There's all kind of, realize you've heard the expression that making laws is like making sausage. You just don't want to see it. You don't want to see what goes into it. I think that's a lot of truth. There's a lot of special interests that have reasons to put stuff in there, and then they add this and they add that, and it becomes this mishmash of special interests, and it becomes really complicated. And then you try to interpret it, and then you end up finding that you have to have an attorney. And again, the Social Security world, I've done hearings for years and years and years. I mean, example today, I had a hearing, a really, really good case, two good cases today. One of them with a judge who has good approval rating. I've never been in front of her. And my client is, very, very smart guy, very involved in the case. He was involved in writing the brief. I mean, really knows what's going on with his body. Smart guy, had a really, good career and very type A, very focused. Well, he would tell you, this judge, boom, boom, boom. She's talking a mile a minute. She's asking about, she's using abbreviation. She's boom, and I knew what she was talking about because I speak the shorthand. I don't think my client necessarily did. I mean, and if he was there by himself, he would not have really, and I prepared him. I said, okay, when they ask you about this is how you want to answer it. And these are the questions you're going to get. And he was ready. And he even told me afterwards, he goes, I'm glad you told me about, how to answer this question, because I would have gone off and blah, blah, blah. It's just the nature of the beast. It's just the nature of the beast. Legal stuff, it just gets complicated. Now, I do expect that, with all the AI engines, that you're going to see certain legal things like simple divorces, name changes, stuff like that, maybe become a little bit easier because, there's really no reason to get a lawyer to do a name change. I mean, it's like, that's sort of like the easiest thing possibly to do. You advertise in the newspaper, you file a petition, and that's it. But, a lot of other stuff is going to become, AI will influence it, but it's not going to take away from the fact you got to make an argument. I was listening today to the to the NOSCR presentation, and there's discussion about a complete overhaul of many of the rules. Well, what is that going to mean? We don't know. We have no idea. But when that happens, it's going to change everything. That if that happens in a big way, everything is going to change in terms of how to prepare cases. Is it going to mean that a 58-year-old with 3 herniated discs is going to not get approved? No, you're still going to get approved. It's just my argument is going to change. My approach is going to change. But you have to sort of know what they want, and you got to know how to present it. So DG was rated less than sedentary. Congressional doctors that can't work with limitations, depression, 2 level before the judge. But at the recon, what type of medicals? I think if you've got functional capacity forms, that's where I would try to get into the recon adjudicator. Maybe you get lucky and get approved. But I think you probably have a winning case if you've got a medical support like that. So once you're insured, generally, now again, if you have gaps in your working, you may not be insured for 5 full years after, but approximately that. Records, the more functional capacity forms you got, DG, the better. The more you have that limits you, the better. So get them all in, is what I would tell you. Neuropsych testing, yeah, that's a great idea. Great idea. Independent neuropsych testing, that's a great idea. This is life. Good thought. Very good thought. That's for post-concussion center. That's what you really need. And Ted, congressional representative link. I think if you just go to Google and type in who are my senators for the state of Virginia or the state of Maryland, it'll tell you. That's all you got to do, really. Christina is here. Somebody was saying, where's Christina? Well, there she is. Okay. We've got about 10 more minutes to go. Stephen says hello from Pennsylvania. Hello, Stephen. Christina, please leave a 5-star review if I've helped you. It's BERG. I'm happy for the 5-star review, but it's Christina, it's not BUR, it's BERG. Not that it's any big deal, but just for accuracy. It does help the firm and the channel. That's correct. It does very much. But thank you, Christina, for tuning in. Once the adjudicator, again, average time frame is going to be about 8, 9 to 12 months for initial, 8 to 10 months for recon, 5 to 7 months for a hearing. So that's where I get the 2.5 years start to finish, with a 6-month leeway either side. Adjudicator is going to, again, it could take 8, 9, 10 months. Okay, leave a review. That's exactly it. How far back do they go transfer? 5 years. I used to be 15, now it's 5 years. 5 years. Dreamers Club, hearing coming up August 1. Really nervous. Been practicing question by ChatGPT. Do you have any other tips? I have a lawyer actually recommended to me, Levine Benjamin. Yeah, I mean, Joe and Gary Levine Benjamin, excellent attorneys. They will prepare you properly. You will absolutely have a good, excellent representation. So it's okay to be nervous, but they are really, in fact, I've been trying to get Joe Ewell on here, trying to work through some computer issues, but both he and Gary, and I think there's another young attorney that I met at a convention. I can't remember his name, but they know what they're doing. So you're in really good hands. Okay, you can still hear me. Good. DG coming back on the 30th. Oh, good. Yeah, that's when Spencer's going to be on. Okay. All right. So this is an answer to high old AG about whether he should wait for surgery. Yeah, don't wait for. He's agreeing with me. Don't wait for the surgery. Okay, I'm going to speed through some of these because I want to make sure we cover as many as we can. Do you think my medical review is not for approval? Why are they asking about wages now? Yeah, I hate to guess what's going on in the mind of an adjudicator because you just don't know. You don't know. And for me to say this is what this means, it's in this stage or that stage, I just can't do it. I mean, when they say you're in non-medical review, that's usually a good sign, but it doesn't guarantee anything until you get in black and white, you've been approved, and you've been approved with the onset date you want. You can't believe it. Okay, so this Mr. P is when you reapplied, gave the same date as the original for the original hearing. You can change it at any point. They may change it for you. But what we're talking about is if you went to a hearing and got denied, then you reapply. The earliest onset date was the day after your prior application. I personally, now again, you also need to make a look at your date last insured. which again, it may be too late to do anything about that. But assuming your date last insured, which will be in your prior decision, has not yet expired, um, you know, I personally would reach out to the adjudicator and say, I understand that the earliest date I can use is the day after my unfavorable. Let's go ahead and change that so we're all on the same page. That's what I would do. But, I don't want to give you legal advice because there's a lot of moving parts here, but that's what I would probably do. What city am I in? I'm in Atlanta, Georgia, although I represent clients all over the country because hearings are done by video or phone like this. I do not know Steve. I mentioned I'm going to be in Traverse City, Michigan next week for a wedding for a family friend's daughter's getting married. That's just what we're talking about. And Vince, who's one of my clients in Michigan, said, go check out Mackinac Island. So I'm in Atlanta, but again, I do my hearings. I have hearings in Texas, Florida, Oklahoma, California, a lot of them in California, Arizona. I'm, any place in the country, I take them. So again, if you want a case evaluation, you see it here. Doesn't matter where you live. I can do cases all of it because most of them are done by phone, some by video. They use Microsoft Teams, not Zoom or anything, but it's same kind of thing. So that's what I do. I was denied but appealed, got approved for Georgia Vocational Services. I'm confused. I don't know what that means. Don't know. I honestly don't know, blessed hands. What is I don't know anything about Georgia Vocational Services. I'm sorry. Took you 3 years, Mount Yow House. Yeah, I know. Steve says test. Hello, Steve. How much money can you work? Well, again, there's two things going on. Again, part of the complication here. One is the trial work period, where you can earn, I think it's $1,110 or something. Let me look that up for you. Where you have 9 trial work period months in any 5-year period of time. And for 2025, trial work is 1,160. You can earn up to 1,160 without triggering a trial work period. Then if you're over that, you have 9 of those to play with. And then once you've used those up, or you're in the middle of applying, the 1620 is what you got to focus on. That is substantial gainful activity. So in theory, big picture, if you work and you earn less than 1,620, you could still qualify for Social Security. Corlil says, hello, Corlil. Hey, Steve. Hope all's going well. Been a while. Added new address for the hard cap application. That suffice. I would do a separate notice. There's no particular form. I just do a letter. I think Jen put together a form, but I would do a separate form to give them the address. I just think it's cleaner. And Robin, no, I do cases all over the country. If you move, it will be reassigned. Yes, it probably will be moved, reassigned. It will be reassigned. So Georgia Vocational Services wants you to go back to school. They can help you. So it's kind of like a way to test the waters. I think those programs are good programs because it shows you're motivated. And if you don't make it, that's good evidence that you tried and you were not successful. So yeah, get those likes up. Yes, absolutely. Great information. Well, thank you very much. I appreciate that. Denied but appealed for disabled people who get to work. They find disabled and connected. I am in Georgia, although again, it does not limit me. before COVID, I was only doing cases in Georgia because, or occasionally I would take them out of state, but you had to travel. And, you had to do a live hearing. And so for me to get on a plane, one time I had a hearing in Texas, which I won, thank goodness. But I had a hearing and it was Dallas or Houston, I think. And I had to fly to Dallas for one hearing. And that basically took my whole day up. And you got to pay for the plane ticket, you ate up the whole day. I won the case, but it's not nearly as convenient as being able to do a case in Dallas in the morning and one in California in the afternoon, sitting here in my, in a t-shirt and shorts, which is what I do on a telephone hearing. On a video hearing, I'll have a coat and tie on, at least, I have shorts on, but I'll have a coat and tie on, up front. So, yeah, I think that the hearings by virtual hearings make life a lot easier. All right, Chill Mode says, thanks. Have a great evening. Well, I appreciate that very much. Okay, so we're kind of at the end here. Just to let me just put this on here one more time. If you have a chance, please take a second and fill out our survey. That would be great. Again, this is about some AI programs we're looking at doing. If you want to, and I will be here. Thanks. I'll check into it. Love the format. Thank you, Steve. Great. Yeah. I just, I'm just me. I'm just like to be me. Just talk about what I want to, I think, lawyers, sometimes people lawyers have a reputation for being really stuffy. I'm just plain old me. I'm not really, I don't kind of buy into that whole thing. And, I talk to the people, treat people that want to be treated. So, that's what I'm all about. But I will not be here next week, just to restate that. I'm going to be in Michigan, in Traverse City, Michigan, on the 16th. I will be back on the 23rd and the 30th, and months and weeks after that. So I will not see you next week, but I will see you in 2 weeks. I will put something up here, probably in the live stream, that just says I will not be here this week. So for next week I won't. So I hope everybody has a great couple of weeks, and I will see you back on the 23rd. So until then, everybody be safe and take care of each other, and I'll see you in a couple of weeks. Bye-bye.